Hi, Eric.
Hi, Deb. How's it going?
Good. I'm waiting for our facilitator, our presenter.
Okay. Are you able to see how many people are, is that 9 people in this session?
I'm sorry, I had myself muted.
That's okay. Yeah, sorry, I'm on the road. I had to stop off to do this. So it's been a busy day.
Do you have me now?
Hi, Kate. Eric Crawford is on as well, and he's going to introduce your session.
Great,
and
thanks, Eric.
Get you going. So, okay, Eric, it's up to you.
All right, we're live. Good afternoon. My name is Eric Crawford. I'm the Director of Sales for North America here at Fawn Construction. We're excited to sponsor the Contract Education Series. Today's session is understanding risk allocation in contracts and contracting to protect your status as a project creditor. This session is presented by Kate Strauss, Esquire. Kate Strauss is a founding partner at Galvanize Law and the chair of the ASAC Women of Construction Committee. She is regularly recognized as a Colorado super lawyer for litigation, and she specializes in counseling and educating her construction clients on contract negotiation, risk management, defect defense, mechanics liens, and insurance coverage.
Thanks so much, Eric.
My pleasure.
Let me see what I need to do in order to share my screen, because I did bring a PowerPoint with me here today. Can everybody hear me okay?
At the bottom of your screen, you see a TV monitor?
Yep, I've got my screen share going.
Okay.
There we go.
There you go.
So let's run this bad boy. All right. So can you guys both see my face
Yes.
Okay.
Yes.
Let me figure out how to minimize what I'm doing so that I can also see the chat box. Because I will tell you that without everybody else on video and talking to me, this is going to feel like I'm just talking to myself without some interaction in the chat box. So I hope everybody will feel free to pop into the chat box, ask questions as we go along here. Make me feel a little less alone on this screen. So thanks everybody for joining me today. My name is Kate Strauss, as Eric introduced me. I think I already know a fair amount of the people that are here at this presentation with me today. So some of this stuff is probably things you've heard me say before. I wanted to really, though, look at the concept of contract negotiation by thinking about contracts and about construction projects really from the higher level of subcontractors' status as a creditor on a project, because I think that really helps you to approach what contract negotiation and projects look like for you and for your company. So much of the time that feels like there's a push to make the sale, to get the project going, without necessarily diving into the details of the contract or being afraid that if you try to negotiate the contract or push too hard on the contract, you're not going to make the sale, you're not going to get the project, you're not going to get it going. And there's a couple of things I'm sure most people on this chat have seen and appreciated before. Not every project is the right project for your company. And so when you think about the fact that really your company is advancing time, materials, all of these things on a project, that's part of the risk you're taking. And so how do you protect that risk and protect your status as the creditor? There I am. This does work. All right. So this cartoon is like my favorite way to introduce myself because I feel like it's what I do half of the time, especially because of what I like to do, working with construction professionals. I do think that I enjoy my role being the person who translates your concerns into the mumbo and the jumbo of the legal world and of dealing with some of the technicalities of contracting and litigation and kind of all of the things that flow from working with contractors and construction professionals. So I broke this presentation down into a couple of key areas. I'm starting with just a high level talk about risk allocation, contract negotiation. And then really I thought it would be helpful just for me to cut straight to the top tips, because I don't want you necessarily to wait for a summary at the end of the presentation to kind of get to the heart of what I think is important for you to be looking at and considering internal to your organization when you're thinking about looking about negotiation and risk allocation. And then finally, I broke it down into some of the key areas for contract clauses and different contract concepts that I think are important for everybody to be thinking about and looking at education internal to your organization. So before I get started, does anybody have any questions or comments? Anybody want to type in the chat box just to confirm that I'm not sitting here by myself talking at a screen into space? Thanks, everyone. I appreciate it. So risk allocation is affected by the, oh, look, everybody's here. I appreciate it, you guys. I really do. So risk allocation in contracts. Project contractors and subcontractors are often presented with contract terms that shift the risk, even of things that are not necessarily within your realm of control, over into kind of your bucket of responsibility on a project. And it's inherent in all construction projects. There's different types of risk. And I think that I tried to break down some of the different types of risk you can be thinking about as you're considering what's important to your organization and how you're negotiating contracts. So as you look through this, operational, where's the risk falling for planning changes, scope changes? What does your bid look like? Does your bid include a general reference to a section of a spec book? If that spec book is incorporated in project documents and it says that the most stringent standard will apply, does that mean you've now bought any type of responsibility for an application of one of those standards that wasn't necessarily what was in your brain when you bid the project? So that's one area where you can have a risk that's being allocated to you that you're not necessarily thinking about at the time that you put the bid into play and bid on the project. Cost escalation, that's another one. A lot of people really with the COVID situation found themselves not having force majeure provisions in their contracts or other provisions in their contracts that allowed them to pass on a cost escalation when we started to have increased costs for materials and supplies. Schedule changes. Are you biting off contract provisions that are requiring you to absorb mobilization and demobilization costs related to schedule changes? Labor procurement risks, depending on where your labor comes from. I know some of my contractors rely heavily on being able to bring in visa workers and the J9 program as well. And so there's a question of what's your risk, and have you done or can you do anything to allocate it? Or are you taking on other people's risks as part of your contract? Financial, so costs of warranties, guarantees, delays in payment, project financing, pay term risks, hazards. So hazards can be a lot of different issues. It's not just unsafe workforce behavior or negligence. It's also issues related to defects and who is going to bear the responsibility for defects. So some of the contract clauses that we typically see will say, that if your work is subsequent to another trade's work, you are agreeing that you have reviewed that trade's work, you've examined it for sufficiency. I see it a lot. Here's an interesting one when I represent landscapers who are being sued for issues related to grading and drainage. Usually the landscaper will have some kind of exclusion where they say they're not responsible for setting the grade. And so they try to prevent the allocation of that risk to the landscaper. And then they'll have potentially a contract provision in a master subcontract agreement that says that they confirm that they did inspect the work of the prior trade. So what's really the scope then of that inspection? Is it that they should be out there shooting the grade to confirm that the grade relates or conforms to whatever the project documents required? Or are they simply supposed to be looking at it to say, well, generally it looks like it's falling away from the foundation, so it's probably fine. And if the contractor is telling me to go ahead and put landscape material in, I'm going to put the landscape material in. That really turns into a question of who decided to bear the burden or understood that they were bearing the risk or responsibility for grade. It was not my landscaper at the time they signed that contract, I guarantee it. But on the other hand, if they didn't read through the contract, that's going to be the issue where they need to think about how you can have downstream liability and how you can and should be communicating with the contractor about what it really means for you to be executing some of those terms and provisions. I covered this a little bit already, but when you have improper risk allocation, it doesn't just impact you as a subcontractor who kind of is looking to bid the job and is frankly understanding or thinking that you might be suffering unduly by signing, a master subcontract agreement that has a lot of burdensome provisions in it. Because think about it on the contractor side of the world too. They're the ones who are facing increased job costs due to increased bid contingencies. If you're going to be signing some kind of draconian agreement or you can't get any negotiation or budge on the terms of that contract, it's going to potentially result in increased overall project costs for that contractor. Dispute distractions is another one where now you're fighting over change orders and whether you timely submitted them, or whether you threaded the needle on whatever project requirements they have versus focusing on project completion. Delays, disruptions, overall increased transaction costs. So there's a lot of reasons to think about risk allocation as a conversation and thinking about who has assumed what risk as part of a contract. So uncontrollable risks. These are really the risks that, like I said, you don't necessarily believe that you should be acquiring or assuming as part of a negotiation. And if you have a contract clause that's asking you to do so, you really have to think about what your risk tolerance is for those type of risks. This is all of us, right? Negotiation is a discussion about expectations and standards for how the project is going to proceed. So it can be a little difficult. I understand that, especially when the person that you originally are talking to, when you're bidding the project and talking about scope and talking about what is going to be required as part of the project, you can have all these great conversations, and then you send over your bid proposal and somebody else in procurement sends you back a 50-page contract that doesn't necessarily match up to what you talked about, what you were expecting. And now the person who you were originally talking to says, no, like, just don't even worry about it. Well, you do have to worry about it. And you have to figure out how to say, hey, I want to make it clear that we both understand how the project is going to proceed, that I know what my roles and responsibilities are, and I know what I have and haven't accepted or assumed as potential risk on a project. And don't be afraid to approach negotiation in that manner. So these are my top tips. List your bid proposal as a contract document. That's one way that you will be able to keep your scope of work really clearly defined. And that can be super helpful when you are dealing with a contract that has a long list of contract documents. I'm sure you've seen it in master agreements before, where there's a super long list of contract documents facing you. And it might include a spec book, which you may or may not have actually been provided as a part of whatever documents you did your bid based on. It could include a prime contract agreement that you've never seen before. And that prime contract agreement could have a reference to a set of plans that may or may not be the set of plans that you bid off of. And so because those master agreements can have these little tendrils wrapping around all of these different little bits and pieces of information that they're trying to draw into your contract in order to protect themselves, like I was talking about with scope creep, in order to protect themselves in case now you've got a designer and architect on the project who comes in and says, you know what, you really do need to add flashing at this area, and it's going to be, I don't know, however many thousand linear feet. And by the way, you need to buy it because it qualifies as the most stringent detail. If you look at the detail in this section of this, whichever design document or subsection of this spec book standard. So that's where you can have this kind of crazy scope creep, and they'll just keep pulling it in based on your master agreement references to multiple other contract documents. So the easiest way for you to contain some power over that is to list your bid proposal as a contract document, as one of the ones listed in that MSA. And that's usually something you can find some give on when you're negotiating with contractors. And then use your bid proposal terms and conditions as your litmus for revising and negotiating key provisions in the master agreement. So what I mean by that is if you have a standard set of exclusions where you say, you know, if you're doing the dirt work on a project, if you're doing backfilling compaction and you say, we are going to do it to this level, but we're not responsible for performing independent testing, and we're not responsible for like confirming the accuracy of any inclusions, exclusions in a soils report or anything like that. If that's your standard exclusion and you already know that that's what the sticking point comes to when you are in the middle of a project and you have and you've had this dispute before regarding what really the scope of your work is going to do or what people want to kind of shoehorn into your scope of work, that's where you use your bid proposal to have some clearly stated exclusions, because you know those are your sticking points. And then you think about what those exclusions are as you're reviewing the master contract agreement and thinking about how or whether those exclusions are somehow being written out or guided out of the things that are important to you. Hold on just a second. I'm going to rearrange my screen a little bit so I can look at the camera, look at my presentation, and know what you guys are talking about. All right, there we go. Okay, more top tips. So get the prime contract. so much of the time your prime agreement is going to be incorporated into your subcontract agreement. And so if there's a prime contract between the owner and the contractor, you really, really, really need to know it, because most of the time, if there's a liquidated damages provision, you are going to be tying yourself to that liquidated damages provision. And if you are a trade, especially one that comes toward the end of the project where there might already be issues with scheduling and delays, I mean, shoot, what happens if there's a $10,000 daily liquidated damages provision and your contract was only for $30,000 to begin with, and you get told that you are starting really like on the last couple of days or weeks of whatever the original scheduled time period is? That puts you in a pretty precarious position, because if you have a contractor that's looking to tag your trade as pushing the critical path on that schedule, now all of a sudden you've got this huge liquidated damages provision that's probably going to eat the entirety of whatever your contract value was, and certainly any profits you're ever going to make on the project. So it's good to know if liquidated damages exist, and it's good to consider negotiating them out or reducing them down in a contract. At a minimum, if you are having to tie yourself to a liquidated damages provision, it's a good thing to think about finding a way to make a standard for what they have to prove to tie liquidated damages to you. So if it is simply that the contractor says if they are assigned liquidated damages, then they will be able to share them to you at their discretion or on a pro rata basis. You want to say, no, if I'm going to be exposed to liquidated damages, you have to prove that my work delayed the project critical path, something like that. You want to kind of create a causation standard. You're also looking for things in the prime contract, like a waiver of lien rights, where a contractor has said that they waive the lien rights and that they're going to bind all of their subcontractors in the subcontract agreements to waive their lien rights as well. So you want to know if somebody already tried to strip something away from you in that prime contract. Terms of contract cancellation, what rights does the contractor actually still have as it relates to their relationship with the owner? And then obviously retainage, so you know what is flowing down to you. And this is a big one too, and it's applicable to your contract with the general contractor as well. Are there agreements that are going to have you bound or required to continue to keep working on the project despite a payment dispute? Because that is the worst, when we have a client who has been chronically not getting paid, and you look at the terms of the contract doesn't give the subcontractor or the contractor any right to stop working if they haven't been paid for 30, 60, 90 days, whatever. But instead it's got some provision that says that despite any dispute, you agree that you're going to continue working and not delay the project. That's really where you start to feel the heart of this idea that you are a project creditor, if you don't even have the right to stop working on the project once you sign that contract. Let me go back to that screen. One other note is, this is in the reason we call it, the reason that it's the practice of law and it's an art is because even if you have an agreement that says you're going to keep working despite this payment dispute, there are legal arguments we can make. There are arguments we can make about people acting in bad faith, about them constructively breaching the contract. So your lawyer can help you if you're in that situation and we're having to deal with that clause, but it's so much better and cleaner if you can be heads up and be looking at and really thinking meaningfully through what some of the implications of the clause are going to be in the first instance. Top tips. Nathan, you're here. Have your insurance broker or agent review the insurance provision requirements. This is so helpful, because half of the time we see these every single time, he says, yep. I mean, so much of the time these contracts will have insurance provision requirements that Nathan literally, he cannot get you a policy for what they're asking you to insure. It'll be crazy things like insuring their liability, insuring every type of damage, exposure, etc., stuff that insurance policies aren't even really ever written to cover or provide. So you need your broker to be helping you take a look at that to understand if that's actually what the policy you have in place covers. And if it's not, how to get a revision section in place or negotiate what you actually can insure. And the reason that that's important is because your insurance policy is also there to cover like the liability you're taking on as part of this project. So it's going to cover, or should be trying to cover, some of the things you agree that you're going to indemnify this general contractor before. Keep your organization informed. This is just a straight pragmatic kind of recommendation. And it's an area where I see, oh, Nathan says, and also plan for possible increase in cost on your policy. I think that's a really good point, Nathan, because so many of the contracts require you to name somebody as an additional insured under your general liability policy. And if you have that requirement in your contract that you have to name the general contractor as an additional insured, please, please, please make sure you're talking to your broker about that, because you need to know and understand whether you're naming them as an additional insured for ongoing operations, which would be the ones day to day. So if somebody gets injured on the job site, if one of your workers injures somebody else, that's ongoing ops. And so now you've got the general contractor who's being insured and covered for that under your policy, meaning that you've got a policy in place to take care of your liability for that issue, and they're insuring the general contractor and paying their defense fees and costs as an additional insured, meaning that you're taking care of the defense and indemnity part of your contract obligation. And then there's the completed operations additional insured endorsement, which is where, Nathan, you're obviously typing additional insured completed operations endorsement is also an area where you can have some increased cost, I think, because now what you're saying is, yep, I agree that this person is going to be insured for completed operations, meaning anything that happens or goes wrong, this is usually the construction defect arena after I leave the job site. So in 5 years, we have catastrophic water damage, and it's coming in through the area of the flashing that you was added to your scope as part of the scope creep questions. So you want to make sure that you've got the appropriate insurance in place to cover both you and the general contractor as a completed operations additional insured as well, because that's also a part of what your defense and indemnity obligations are under the contract. So there's a very close tie between what you're doing and agreeing to place on the insurance side of the world with the liability obligations that you're taking on under the defense and indemnity side of the contract. Oh my gosh. Okay, 3 o'clock. So another half hour. I think I'm going to be on track. So back to my top tips being the pragmatic side of the presentation. A lot of areas where I see my clients just sort of struggling from a pragmatic perspective is, how do you implement the terms of your contract internal to your organization? What I mean by that is, you'll have contracts that say, pay applications are due on this date of the month. If you don't get them turned into us up by this date of the month, you don't get paid until, the following month. Number of days after you have notice of an impact to your work. So did the contractor or owner cause a delay to the performance of your work? Do you need additional days added to the time or schedule for your portion of the contract? How many days do you have to give them notice of that? Usually change order requirements. There's no additional work without a written change order. Not always, but usually. And so how do you have a system in place internal to your organization to say, if there's going to be a change order, this is how we're going to push it out? Do we know how many days we have? If there's not for the one where you have the written change order before you do the work, but in instances where you've been instructed to change or alter work in the field and you think you've had a cost impact due to that, how many days does the contract give you to submit a claim for additional costs? So really, really think about how internal to your organization you can be prepped to know and track any of those day requirements, any of those notice of days, number of days requirements that you have in the contract that you signed, so that you've got somebody who knows and understands when and how things need to be submitted. And maybe that's you, or maybe you have different departments who you're thinking now about how you can have them coordinate with each other to make sure that you've got a seamless handoff from bid execution to bid on the project, execution of the contract, to execution of the construction project. Know your own hit list. So understand what's important to you and what your risk tolerances really are internal to your business. When you look at a contract, or if you're training somebody to look at a contract, what are maybe the top 5 or 6 things that you know that you need or want them to be looking at every time they look at a contract? So these are just some examples. Defense and indemnity provisions. Do you have someone who's going through and just at least trying to strike maybe the defense language out of the defense and indemnity provision? Or looking at payment terms and saying, okay, we know that we don't have a tolerance where we're going to accept a pay if paid clause. We're only going to work for pay when paid. Do we have a risk tolerance related to damages for delay, liquidated damages, change orders, etc.? So are we checking for that? Attorney's fees, non-payment. This is a big one. If you don't have a contract provision that allows you to recover your attorney's fees and you have to sue for non-payment on a contract, you will not be able to recover your attorney's fees. It all has to flow from the contract. And so the worst case is when I have clients who are owed somewhere in the, I would say like $30,000 to $80,000 range. And we know it's going to be a hard fight because that money is change order money. And we don't have a contract provision that says they're entitled to obtain their attorney's fees and costs for any lawsuit that they have to file in order to enforce their rights under the contract. So that's just an awful feeling to be like, that's real money to have to walk away from, but I can't guarantee, but we don't have a mechanism for you to get your lawyer paid. And because you're operating as a corporation, you have to have a lawyer. You can't represent yourself in court for that action. And so when you start having to think about the economics of, am I really going to go through with this? Because I know that I'm never going to get my money back that I have to pay my lawyer. And here I am, I work on an hourly rate. So I do my best I can to run it lean, run it mean, but the money is still going to stack up regardless in litigation. And so we're looking at the amount you're owed and we're fighting for it continuously being eaten away because I don't also have a contract provision that says, and we get to push the bill for the whole thing over onto the person who pays you the money. So attorney's fees, can you cover your costs if you have to sue for non-payment? Scope provisions, we already talked a little bit about that, but making sure that it's really clear what you are performing and the extent of your obligations under the contract, that your scope is super, super clear. Cancellation provisions, do you have a right to stop work if you're not being paid? And then forum selection. I have a case right now, actually, where the forum selection, I believe, is arbitration in the state of South Dakota for a construction project that happened here in Colorado. And that's a bummer because when you're a Colorado company working local and living local, and now all of a sudden, if you need to go enforce your rights under a contract, you're supposed to do it in another state with, if I'm your attorney, I'm not licensed in South Dakota. So now I'm looking for a South Dakota attorney to help you. That really right there will give you pause about thinking how far you want to go and what you're going to do to enforce your rights. So forum selection, while it seems a little bit silly on the front end, sometimes can be pretty important. This is my other lawyer joke. Sometimes I wear this in court. It's my frivolous lawsuit. I look forward to finding a frivolous lawsuit to wear in court one day. I never file frivolous suits though. I just defend them. Payment. So now we're getting into some of our contract specific clauses and talking through a little bit about what's important and some of the clauses that I encourage you to be taking a look at, making decisions about your own risk tolerance internal to your organization. So a lot of you already know what a pay if paid clause is. A pay if paid clause means that you are specifically agreeing that you are incurring the risk of non-payment. So if the owner doesn't pay the contractor has no obligation to pay you, the subcontractor. Versus pay when paid, which is you agree that you will be paid by the contractor when they are paid by the owner, rather than simply being paid, net 10, net 30, however you generally invoice your work on a project. So pay when paid still preserves your rights to be paid. Most of the times the way courts will construe a pay when paid clause is to say you are still entitled to be paid and you haven't given away your right to be paid based on the basis of whether or not the owner pays. So if the owner never in fact pays under a pay when paid clause, the court will still at some point in time say that you are entitled. The general contractor has to pay you because the general contractor is the one who is still holding the risk of the owner's non-payment in a pay when paid versus pay if paid, meaning that risk is transferred over to you and you've accepted the risk of non-payment. So what do I write here? Clause simply allows the contractor a reasonable time in which to obtain payment from the owner before being required to pay the subcontractor from the contractor's own funds. I hope some of you will plan on tuning in tomorrow to listen to Danielle Maya talk about the Sword and the Shield, the Colorado Contractor Trust Fund Act and the Colorado Mechanics Liens Act, because the Contractor Trust Fund Act is a really strong remedy that subcontractors have in exactly this situation, where you have a pay when paid clause and a general contractor who's saying, well, I don't have to pay you now. I said I'd pay you when the owner paid and the owner hasn't paid. Well, the owner might not have paid for every portion of the work or every piece that's been invoiced, but under the Colorado the Trust Fund Act, the general contractor still has an obligation in terms of the money that they take from the owner and paying it out to the subcontractors as creditors to the project first before paying the general contractor. So tune in tomorrow at 2:30 to listen to Danielle Maya talk a little bit about how the Trust Fund Act can really be a strong sword for subcontractors in exactly this type of situation. So enforceability of pay if paid payment clauses. It's interesting because different states treat pay if paid differently. In Colorado, the case law here says that you have to have clear and unambiguous language shifting the risk of payment to the subcontractor. So the clear and unambiguous language needs to be something along the lines of, I agree, contractor will pay me only if they are paid. I assume the risk of the owner's non-payment. Oftentimes too, you'll see it in bold, caps, underlined, so that they're drawing attention to the language to bolster an argument to the court that it's clear, unambiguous, that you negotiated to accept that risk of non-payment. I know that some of you or many of you are working in multiple markets in the Rocky Mountain region. So I just gave you a rundown here on the screen also. New Mexico, pay if paid is an enforceable clause. Texas, like Colorado, their courts say it's enforceable if it's unequivocal and express in the contract. And Wyoming, their courts have not really had, and this is the last time I looked at it, it's actually been a year or so, but there isn't any case law or statute specific to the question about whether or not it's enforceable or not. So I'm going with probably enforceable in Wyoming. Colorado and Texas, both, if the language standard, clear and unambiguous, unequivocal, and express, if you don't meet the language standards required there, then typically they'll just treat it as pay when paid rather than pay if paid. Here's a couple other, and I put this in because it's interesting, not necessarily because I think anybody here is working in North Carolina, but maybe Wisconsin. They all have statutes specifically on point that deal with payment clauses and how they're applied in construction contracts. North Carolina's statute says both pay when paid and pay if paid clauses are unenforceable. So if you're going to contract with somebody for them to provide materials and services on a project, you're going to pay them. Wisconsin voids pay if paid, but will enforce pay when paid. And this is interesting. You can still lien the project regardless in Illinois, Maryland, and Missouri, and say that you're entitled to payment for the project, regardless of whether or not you have a pay if paid clause in play in your contract. So I think it's interesting that different states treat it differently. I think it might be an interesting question for Colorado at some point, and for Colorado subcontractors to think about whether or how we could lobby, but we're also really not living in a market where we have other states around us that have had effective subcontractor lobby to address the pay if paid question here. Final payments. This slide really just talks about thinking about what final payment on a construction project looks like for you and for your company. Usually with a final payment, if you do a unconditional lien release as a final payment, if you do any kind of release as a final payment, you're waiving, like, forever and always your rights of all disputes and claims related to the contractor subcontract. If there are any potential additional outstanding claims for payment that you believe you have submitted or haven't been fully resolved, you really can't sign that final payment or unconditional lien release because it's going to be used against you. So I'm sure all of you are savvy enough to be reading and understanding whether it's a conditional versus an unconditional release as you are proceeding through the project. But really, if it's something that is saying you're waiving forever and always your rights on that project, make sure you know that warranty and punch is where you need it to be, that you don't have any outstanding potential obligations. Really kind of think it through and make sure that you're having that project with, or that conversation with your project manager and project coordinator. Here we go. Payment clauses, contracting for final payment. So here's an interesting issue, and I know that it happens. It's more pressing for my subcontractors that are coming in on the front end of the project to figure out when their time for final payment is. And so I think this is just a sample contract provision here. Acceptance of the subcontract work by owner and constructor and receipt from subcontractor of evidence of fulfillment of the obligations. Contractor shall incorporate your application for final payment into the contractor's next application for payment to owner without delay. So this means you are saying, you've accepted my work, it's final work, you're going to take my final pay app and you're going to submit it as part of your regular applications on the project, rather than being forced to take your final payment at the conclusion of the project or upon substantial completion of the project, meaning that you might be stuck with either retainage or final payment for whatever the trajectory of that project looks like. Also, time of final payment of the balance due shall be made to subcontractor within 7 days after receipt by contractor of final payment from owner for such subcontract work. Those are important clauses to be able to enforce. You want to have them in the contract and be thinking about how it is that you're going to be able to shake your money loose at the end of the project, and be paying particular attention to the fact that there is a timeline that they do have to pay you. Because after you've finished your work, you all know you've now lost your leverage on the project. So it's not like you can say, well, you haven't given me my final payment, so I'm not going to come back and finish my work. You're done, and they'll be messing around with you kind of for as long as they can. I think one of the things I'm really seeing with my clients right now is starting to, I call it the COVID trickle up effect, where we've all been busy. Construction's been booming. Everybody's really been able to work consistently throughout COVID, obviously having to deal appropriately with construction job site guidelines and everything else. But we've got end project users, owners, tenant finish people who are in industries where maybe their cash flow isn't looking the way they thought it was going to look at the outset of the project. And so I've got clients who are dealing a lot more now with how to collect, and having a clause like this in the contract where you know that they are absolutely positively required to pay you within a certain amount of time upon completion of the work is so helpful in terms of actually being able to, give me a leg to stand on as we're fighting to get that money released. Mutual versus unilateral. Let me take a sip of my water so I can really delve into this fascinating topic. All right, mutual versus unilateral. As you're reading contract provisions, pay attention to whether or not you are only binding yourself and your company, unilateral, versus mutual, where you're both equally bound. And so if you've got a clause where you're being asked to bind yourself to the contractor only to the extent that, or to the same manner that the contractor is being bound to the owner, you still want to have the unilateral flow up. You still want to have all of the rights and responsibilities then, or sort of the rights and remedies is the better word, that the general contractor has as they relate to the owner back against the general contractor. So try not to make your provisions just flow one way. Make sure that any benefits that general contractor has flowing against the owner are coming back to you, that it's not just the obligations that are going uphill or upstream. And this concept of mutual versus unilateral is super important. I already touched on attorney's fee provisions earlier in my talk, but attorney's fee provisions are often called prevailing party provisions. And so a standard prevailing party provision will say something like the language on the screen here, that the prevailing party in any dispute arising from the agreement shall be awarded its attorney's fees and costs. So the prevailing party in the dispute arising from the agreement is always really a question that's subjective to the arbitrator or the judge, whoever is hearing the case. The good news is that, again, it's a practice of law, it's an art, but the good news is the prevailing party can be the party that wins on either a claim or substantially prevails on a defense. So if I have a construction defect dispute where you were fully paid for the project, but now there's a litigation happening where they're asserting claims against you related to deficiencies in your work or damages caused by those deficiencies, you might feel like, well, I'm never going to win that because I don't have a claim. But if what we say is, this is a repair, right? It's an easy repair. It's a $5,000, $10,000 fix for the work. And what they're claiming is that a full replacement is required. And that's a $300,000 or $400,000 cost to replace or fully replace, or the worst is foundation movement, honestly, in a structural underpin. That's where what you think is, $3,000 to regrade around the foundation turns into $600,000 to do a structural underpin of the foundation. In an instance like that, if we go and convince the jury, yep, we're just going to do $3,000 worth of grading around the foundation, that's literally all that's required, that's a win. Now we have substantially prevailed on a defense. And so the right judge will say, yep, we agree, the prevailing party is going to be the subcontractor. The other reason it's important, obviously, is, I already just talked about it, you want to make sure you're preserving your right to be able to recover your attorney's fees if you have to sue for non-payment on the contract. And so that's another area where you want to consider, at a minimum, having unilateral flowing your direction. And so this really gets into not so much master agreements with general contractors, but your standard terms and conditions. If you were just bidding a project directly to the end user, owner, client, whoever, your standard terms and conditions should say unilateral kind of provision, right? That we are entitled to collect all attorney's fees and costs that are incurred with enforcement of any of the contract provisions, including but not limited to non-payment, costs to foreclose or file and foreclose on mechanics liens, whatever fees and costs might be related to your enforcement of your rights under the contract. So I guess my final thought on mutual versus unilateral, if you're the subcontractor contracting with a general contractor, don't ever sign a contract that just allows the general contractor to recover their attorney's fees and costs in conjunction with a legal proceeding. So now you've shot yourself in the foot. All of a sudden, you've got a general contractor who is going to be able to get their, look at the way I wrote it, their attorney's fees and costs in conjunction with any legal proceeding. Under that language, they don't even have to win. All they have to do is have to spend money on their attorney. And now all of a sudden, it seems like they're going to be able to collect their money back on whatever they have to spend on their attorney, and you're left hanging in the wind. So that's why this kind of mutual versus unilateral concept is one I want you to pay attention to when you look at contracts. Did I just duplicate that slide? Looks like it. All right, standard of care, no one's perfect. This one is related to, you've probably all seen standards of care in contracts before. It might be tempting to you to take a standard of care clause out of a contract. Do not do that. The reason standard of care contracts exist in contracts is to create the performance standard so that the parties know how the contract is to be enforced and the extent to which it's to be enforced. So you want to be able to say, look, I'm going to act in a commercially reasonable manner. And then if somebody says, well, no, you didn't, you at least have the litmus for which a jury or judge comes in and says, okay, what's reasonable, what's commercially reasonable pursuant to the terms of this contract, because that's the standard to which you're going to be held. So you want to create a standard so that somebody knows how to apply and enforce the contract. You know that you want that language in there, but generally what we want is, I think I have it written here, a standard of commercial acceptability. So you want to have, we're going to do it, perform in accordance with the standard of care applicable to your industry on a project of this size and nature. A lot of times people will say good and workmanlike quality. So you'll see that as a typical standard. You want to stay away from agreeing to something that puts you into perfection, most stringent, first rate, highest quality, but anything that Donald Trump would use to describe the manner of conduct, that it's going to be first rate, the best, nothing better. That's where you want to not be committing to yourself to that as a standard of care in a contract, because you're there to do a good job and you're there to do the right job for your clients, but you're not there to set yourself up for a standard that it's going to be easy for somebody to come in and say, well, that's not the best. That doesn't meet the superlative. Christy. Yes, I believe all my slides are going to be available. I'm going to make sure I get them to Deb. And then also you can feel free to email me directly if you want a copy of this presentation. So I will be happy to PDF it and send it out to anybody who emails me. You are welcome. And I see that I'm going to run short on time. I have like 4 minutes left. So let me blast through these last couple ones and just offer high-level thoughts. So I talked a little bit about this already. Look at scheduling, look at sequencing and mobilization, and make sure that you're not having to absorb the cost of somebody else's crappy scheduling, because depending on your trade and how many crews you're running and the amount of dedication it takes for you to mobilize and get moving on a project, you can be eating up some serious fees and costs when it relates to having to mob and demob. Some sample, this is a suggestion, sample clause on sequencing and mobilization, true cost of defense and indemnity. Boy, I didn't even get into defense and indemnity. All right, I want you to understand that when you agree to defend and indemnify, you are agreeing The duty to defend is different from the duty to indemnify. So this is probably one of the key slides. The duty to defend means I will pay your attorney's fees and costs, and I will pay them from day one that somebody says that I did something wrong. And that is awful because all it takes is an allegation of wrongdoing with your work. So if you get a chance in a clause that says, let me go back. See, it says up here, expense, assume the defense of and indemnify and save harmless. Strike the defense, strike the word defend. And if there's a problem with that, you say to them, look, I am going to do a good job for you on this project, and I'm going to indemnify you. I am going to stand up and be responsible for any judgment that enters against you that arises from my work when somebody actually proves that I did something wrong. And I am going to do my work in a good and workmanlike manner. These are the promises I'm making to you. What I cannot absorb is the potential cost of defense that sets me up to have to pay your attorney's fees from day one, because that is the type of potential liability exposure that racks up so quickly. Attorneys are the worst. Attorneys just, those bills, when we get into a litigation scenario, now you're going to be in this unfortunate position of having to pay potentially your attorney who's involved in the case, and you're paying their attorneys. And so any type of, the value of the contract, any profits you made on the contract, they get eroded so quickly when you're on the hook for defense and indemnity. And I was talking a little bit earlier about that additional insured provision. That's why it's so good to endorse somebody as an additional insured, because it means that now at least your insurance policy has to pay their defense fees and costs. So thank you, everybody. For your kind compliments. I hope that this was helpful to you. Always feel free to reach out to me or anyone on my team. We're always eager to help and available to you to kick around any questions or concerns that you might have. I mentioned Danielle tomorrow will be doing Sword in the Shield, mechanics liens, and Colorado Trust Fund. It's really good if you sort of know what those are, but haven't taken a deep dive into them to maybe sit and listen to what Danielle will tell you about it. And then on Friday, Jenny's going to be doing warranty work and bonding versus insurance. So all concepts that we want you to be able to know and understand so that you have the tools you need in your toolkit. Thanks, everybody. Have a great day. Enjoy the rest of the conference. And thanks so much to Deb for doing such a great job organizing this. Take care, everyone.